Hello everyone, welcome to the channel and to Article 20 of our Constitution under Part 3 Fundamental Rights, which is protection in respect of conviction for offences. Clause 1 No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might be No, which might have been inflicted under the law in force at the time of the commission of the offence. Second, second clause, no person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. So, Article 20 deals with the protection of certain rights in certain case of conviction of a person for any offence. It grants protection against arbitrary and excessive punishment to an accused person, whether he is a citizen or a foreigner. It contains three provisions. 21, 20, Clause 1 deals with ex post facto laws. This is 20, Clause 1. Article 20, Clause 2 deals with the principle of double jeopardy. Article 20, Clause 3 deals with the principle of prohibition against self incrimination. Ex post, first, ex post facto law, according to Article 20, Clause 1, means that no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, nor be subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. Ex post facto law is derived from the Latin word ex post facto, which means out of the aftermath or retrospective effect of law. The protection under Article 20, Clause 1 is in the field of criminal law only and not for any civil liability, and this prohibition is in respect of substantive law and not in respect of procedural law. See, beneficial ex post facto laws are not prohibited. In Ratan Lal versus State of Punjab, AI 1965, the Supreme Court held that retrospective implementation of criminal laws where an accused gets reduction in punishment is not affected by Article 20, Clause 1. Beneficial ex post facto law is not prohibited. Thus, Article 20, Clause 1 prohibits the imposition of enhanced penalty or punishment, but it does not bar any reduction in the punishment. Only conviction or punishment is prohibited. In Mohanlal versus State of Rajasthan, AI 2015, the Supreme Court held that only conviction and or punishment under an ex post facto law is prohibited under Article 20, Clause 1 and not the trial or prosecution itself. The Supreme Court also observed that trial under a different procedure than what existed during the commission of the fact of the act does not come under the ambit of the same and cannot be struck down as unconstitutional. Procedural right of citizen in Union of India versus Kumar Pine 1966. The court held that Article 20, Clause 1 does not grant any citizen a right for any procedure adopted by the court as a fundamental right. Thus, if a law retrospectively changes the place of trial of an offense from any particular court, for example, a criminal court to any tribunal like administrative tribunal, it doesn't get any protection by Article 20, Clause 1. Now, the double jeopardy under Article 20, Clause 2 states that no person shall be prosecuted and punished for the same offense more than once. It's a very fundamental quest of law. It is based on the common law maxim nemo debit vexari, which means that a man must not be put twice in peril for the same offense. This rule contains the following essentials. Number one, person must be accused of an offense, which means an act or omission made punishable by law for the time being in force. Number two, the proceeding or the prosecution must be taken place before the court or judicial tribunal. Number three, the person must have been prosecuted and punished in the previous proceeding. Number four, the offense must be the same for which he was prosecuted and punished in previous proceedings. However, proceedings before departmental and administrative authorities cannot be a proceeding of judicial nature. Prosecution and punishment for two different offenses does not amount to double jeopardy. No double jeopardy in A. A. Mullah and others versus the state of Maharashtra, AIA 1997, the Supreme Court held that if the accused was neither convicted nor acquitted on the charges against him in the first trial, the second trial, retrial, would not amount to double jeopardy. No double jeopardy war if there was no trial. It was held in recently in the Supreme Court in by the Supreme Court in state of Mizoram versus Dr. C. Sanghina, AI 2018, has held that where the accused has not been tried at all, neither convicted nor acquitted, the principle of double jeopardy cannot be invoked at all, and thus the bar of double jeopardy will not apply if the person was discharged due to the lack of evidence. Difference between Article 20, Clause 1 and Section 300 CRPC, which is now BNSS, Bharatiya Nagrik Swacha Sanhita, is mentioned in case Kolla Veera Raghav Rao versus G. Venkateshwara Rao 2011. The Supreme Court stated that Article 20, Clause 1 embodies the principle of outre foi convict, which is spelled as AUTREFOIS, convict, CONVICT, which means outre foi convict, which means that if a person is prosecuted and punished for a particular offense, he cannot be put on trial for the same offense again. Whereas Section 300 of CRPC, along with this principle, embodies the principle of outre foi acquit, which means that if a person is charged and subsequently acquitted of the offense, he cannot be put on a trial for the same offense again. Double jeopardy and issue estoppel. While Article 20, Clause 2 bars double punishment, rule of estoppel bars reception of evidence on an issue on which finding was in favor of the accused at a previous trial. Article 20, Clause 2 has no direct bearing on the question at issue, while what is required for the application of the rule of issue estoppel is the identity of issue and the acquittal of the accused at a previous trial on the same issue, while Article 20, Clause 2 would be attracted if offense is the same in the second prosecution. Issue estoppel is different from double jeopardy or outre foi acquit. In Ravinder Singh versus Sukhbir Singh and others, 2013, the Supreme Court held that the principle of issue estoppel is also known as the cause of action estoppel, and the same is different from the principle of double jeopardy or outre foi acquit. In order to invoke the rule of issue estoppel, not only the parties in the two trials should be same, but also the fact in issue, proved or not, as present in earlier trial, must be identical to what is sought to be re-agitated in the subsequent trial. The rule of issue estoppel prevents re-litigation of an issue which has been determined in a criminal trial between the parties. So the right against self-incrimination, Article 20, Clause 3, which is given here. No person accused of any offense shall be compelled to be a witness against himself. Article 20, Clause 3 is based on the common law maxim nemo tenetur procedure accusare sepicem, which means that no man is bound to accuse himself. This protection is given only if the following ingredients are present. Number one, it is a protection available to a person accused of an offense. Number two, it is a protection against compulsion to be a witness against oneself. And number three, it is a protection against such compulsion as relating to his giving evidence against himself. Meaning of term witness is given in MP Sharma versus Satish Chandra case, AIN 1954. The Supreme Court gave a wider interpretation to the expression to be a witness to include oral, documentary, and testimonial evidence. Giving thumb or foot or palm impression, etc., are not covered under Article 20, Clause 3. It was stated in the state of Bombay versus Kathi Kalu, year 1961. It was held by the Supreme Court that giving thumb impression or impression of foot or palm of fingers or specimens of writings or exposing body for the purpose of identification are not covered under Article 20, Clause 3. Article 20, Clause 3 also applies to investigation stage. It was given in Nandini Satpathy versus P.L. Dani, AIR 1978. The Supreme Court ruled that the object of Article 20, Clause 3 is to protect the accused from unnecessary police harassment and has it extends to the stage of police investigation apart from the trial procedure. Polygraph, narcolysis, and brain mapping test were talked about in Selvi versus the state of Karnataka, AIA 2010. It was held that compulsory polygraph Narcolepsy and brain mapping test amounts to testimonial compulsion and attracts protection under Article 20, Clause 3. The voice samples, as mentioned in Ritesh Sinha versus State of Uttar Pradesh and others versus Union of India, AIR 2019, the Supreme Court held that the magistrate has power to direct an accused to give voice samples during investigations without his consent. So, yes, this was all about Article 20, which was right against self incrimination, protection in respect of conviction for offenses. Thank you.